Julian Cardenas Garcia, and he is the newly appointed director of the Center for U.S. and Mexican Law. So, I want to now turn it over to our moderator, Professor Garcia, who is going to introduce the speaker.
Thank you, Karen. Welcome, everybody. Welcome those here in the classroom. Welcome to those online. It is a pleasure for the University of Houston Law Center, particularly on behalf of the Center for U.S. and Mexican Law, to host today Alejandro Celorio, legal advisor of the Ministry of Foreign Affairs of Mexico. As an alumnus of the Law Center back in 2007, as Karen mentioned, we're very proud that Alejandro's career connected with international law led him to this honorable position at the Ministry of Foreign Affairs. And we're pleased to have him here today presenting Mexico sues the U.S. gun industry. Very interesting presentation dealing with illicit traffic of arms, a transnational issue that which solution goes beyond the power of any individual nation state. It requires international cooperation and it requires the participation of multiple actors. So Alejandro has been a member of the Mexican Foreign Affairs Service since 2006. And as I said, he serves currently as the Foreign Ministry Legal Advisor. Before that, he worked as a deputy legal advisor in the Mexican Embassy in the United States, where he worked to defend the interests of Mexicans in the US, especially undocumented Mexicans. He has experience in strategic litigation and in working with pro-immigrants and civil rights organizations in the US. He has also been posted to the Mexican consulate in Sacramento, California as consul for protection, and to the embassy in Paraguay, where he was in charge of political and economic affairs. He's a graduate of the La Salle University Law School in Mexico. He also has studies in legal sociology in Spain and postgraduate studies in Mexico, and an LL.M. from the University of San Francisco and the University of Houston. So Alejandro, we're very pleased to have you here, and the floor is yours for the presentation. I will later present the moderators that we have for today's presentation, which are Professor Tim Webster and Assistant Professor Jessica Berger.
So 30 minutes around?
Share screen. Share screen. All right. Share screen.
All right. Well, thank you very much. It's such an honor to be back in UFH. I recognize Ambassador Alicia Kerber, Consul General of Mexico here in Houston, and my colleagues from the consulate. Let me start with the basics and the obvious things. This is a lawsuit that is not or not challenge the Second Amendment. This is not a lawsuit against the United States. It's not a lawsuit against the US government. This is not a lawsuit against Americans. This is a tort law. It's a civil lawsuit. I want to call your attention as law students and interested in these topics to two main concepts. The fact that this is a transboundary tort, and I believe we, as our border dynamic and the world moves faster and faster and gets smaller, we'll see a lot of this kind of litigation where the action or inaction happens in the territory of one state. and the harm or the injury happens in the territory of another state. In this litigation, we claim that the action and inaction happens in the United States and the harm we suffer in Mexican territory. That's one concept that I believe will be of your interest. And the other one is the concept of extraterritoriality of a domestic statute. Based on domestic law and notions of international law, the statutes are designed to have force and govern within a national jurisdiction, unless it is stated otherwise. Now, the theory or the theoretical question would be how a domestic law that frustrates access to justice for a third party in another territory could survive in this moving and at the same time, it's a world that is getting smaller and smaller. Now, I'll start. This answers the question of why. Why are we suing the gun industry? This is the kind of seizures that we perform in the northern area of Mexico. This is perhaps the biggest seizure of weapons and munitions, just if you see in this slide. Almost 3 million munitions. Look at the kind of weapons. These are military style weapons that were seized. And of course, they were not for hunting, they were for killing Mexicans. This is cartels. How are these weapons used? This is the vehicle, and it's heavily armored. This is the chief of police in Mexico City, in one of the areas, nicer than Goodlands, if I can put it this way. It's the very residential, very wealthy, in Mexico City. These are Barrett 50, brand new Barrett 50. The Barrett 50 will bring a helicopter down. These are hulls of a Barrett 50, more than 400 shots against the chief of police in a very nice area in Mexico City. Those weapons are not sold legally in Mexico. They're sold legally to civilians, to individuals in the United States. Starts getting interesting when we think about two different territories, two different legal systems, two different social contracts. While in the United States, and we by no means would attempt to criticize or even question the social contract in the United States, you can buy weapons, firearms of military style, military kind, in the United States freely and openly. In Mexico, we only have one store managed by the Mexican Army. You cannot buy weapons of this kind in Mexico. There's no way. Between 70 and 90%, and this is ATFs, the Alcohol, Tobacco, Firearms, and Explosives Agency, the federal agency, according to their statistics based on serial numbers traced. And this is a theoretical map. This doesn't represent any evidence because the tracing of the weapons is not public. There's something called the TR Amendment in US law that doesn't allow ATF to release tracing information. But this gives you an idea of how it goes from a legal buying to a criminal scene in Mexico. It's a breakdown of the 70%. And I want to call your attention again on the kind of weapons. When we talk about firearms, people might think, well, it's handguns. No, these are military style weapons. If you haven't had the chance, and it's extremely sad to see it in social platforms or internet, you'll see the cartels burying the weapons because they want to threaten society, but also in narco series, and also in books, and in the newspaper, and in governmental reports. And this is the basis of our claim. The gun industry is negligent, and I'm talking the gun industry, the manufacturers, the distributors, and the dealers, they're negligent because knowing that their product ends in the hands of criminals, they're under notice. They have the tracing information available to them. They do nothing to prevent that the weapons and in the hands of criminals. On the contrary, they facilitate through their negligence that criminals access to these weapons. On August 4, 2021, the Mexican government sued as a plaintiff. We are the plaintiff. We are the one that suffered the harm. What is the kind of harm that we suffer? Direct harm. Soldiers, police officers, judges, civil servants have been shot or hurt. Our vehicles, helicopters, our buildings have been shot. We need to replace them. We need to spend, we need to distract budget from social programs to respond to armed violence. That is the harm that is suffered. We claim in this lawsuit that the amount of money that we have to direct to respond to armed violence caused by the illicit traffic of guns that is facilitated by the negligence of the gun industry amounts to around 6% of our GDP, which is tens of that $10 billion, something like that, between 10 and 16. These are our claims. This presentation will be for you. Really bad in following my own presentations, but just to explain other claims that we have in terms of what is facilitating the illicit trafficking of weapons. This is the marketing of their products, the design of their products that make them appealing to cartels. The handgun on your extreme right, that's the flag of Mexico with the national symbol in there. I don't know how many people in Kentucky would like to buy that gun. There's examples of handguns called mainly Jefe de Jefes, El Mayor, El General, or with designs of the Mexican Revolution. It would be very interesting to see what are the marketing decisions of the gun industry to either design or allow their products to be modified for an illicit market in Mexico. Another example, and this is the Sandy Hook case has been very successful in talking about deceiving marketing or violating the consumer protections law. This is a scene of war, right? I mean, it immediately takes you to Syria, to Yemen, to Somalia, but it's in a magazine for the public that you find in the airports. So there's a sense of marketing that will call the attention of cartels or criminals with the message of you can do harm, the most harm with this product. This is not a weapon that is sold to teach your grandchildren how to hunt deer. This is a weapon marketed to hurt people. Of the litigation, and the explanation is very broad of what we're doing, I want to call your attention to the amicus briefs that we filed. This is an example of the amicus briefs that were filed to the district court. We filed our lawsuit in August in Boston, Massachusetts, the federal court in Boston, Massachusetts, first stage, right? Why in Boston and not in Texas, not in Arizona? Two main reasons. Smith & Wesson's headquarters is there. We needed to nail personal jurisdiction. Barrett is not in Boston, Massachusetts. It's in Tennessee, but it does business, sells through Boston, Massachusetts. In his decision, the federal judge, our case got dismissed. Sorry for the spoiler, got dismissed at the first stage. Got dismissed not on personal jurisdiction, not on standing, for a different reason. Why is it important to talk about the amicus? Because these are 27 district attorneys saying this case is important for Americans and American communities because the guns empower cartels. Cartels traffic substances, traffic people. The guns go back to American communities. 14 attorney generals led by the Attorney General of Massachusetts saying, FLACA, this is very interesting because we're a foreign government. So it was back then very difficult to talk about the domestic law. So the attorney generals stated FLACA is frustrating the state's entity's ability to provide a remedy. US law professors talking about the presumption of non-extraterritoriality of PLACA. PLACA is the immunities statute, and I'll stop to explain a bit more. Gun control groups, international law professors, countries in the region, and victims. The government of Mexico is suing as a plaintiff. The victims could have sued, and Judge Saylor, the district judge, gave us a hint in his decision saying, you could have had a remedy if you were actually a victim, like an individual. Why is it that we didn't sue or we didn't organize a class action, for example, or a group of victims? Sadly, we have thousands, tens of thousands, hundreds of thousands of victims. To organize such a group to bring a suit against Barrett, Smith & Wesson would be very hard. Second, this is so important, and we know that we're facing an uphill challenge with the gun industry and the resources that they have, that it had to be the government of Mexico that has suffered harm that brought this suit, because we have access to tracing information, we have access to other agencies, and we have a louder voice than a single individual. PLACA. PLACA is the elephant in the room in our case. PLACA, for those that do not know about this, is a statute that provides immunity to the gun industry against civil liability. PLACA is the statute that has frustrated the majority, if not all, the lawsuits that are filed after a gun shootout or a shooting or a massive attack in the United States. Judge Saylor, in his decision, it's a 44 pages decision in the Boston case where he recitates the facts in our claims saying we only have one store, Mexico only has one store, the majority of the weapons come from Mexico, there's harm suffered. Didn't dismiss the lawsuit on lack of standing, didn't have to go on the examination of personal jurisdiction, just said, PLACA, there's a law. I cannot contravene a law that is in effect. Your lawsuit is dismissed. We were expecting that. We were expecting the dismissal of our lawsuit. We were hoping that our lawsuit was gonna prevail. The three main arguments and a brief summary of how we believe we could overcome PLACA are as follows. We claim the harm is suffered in Mexican soil under less lucky delicti. I believe it is the substantive law that applies under tort law is the law of the place of harm, not the place of the action, but the place of harm. Therefore, the substantive law that should apply in this case is Mexican law. In Mexican law, there's no PLACA, there's no immunity, therefore our case should advance. If the judge had decided the law that applies is the law of the United States where there is PLACA, all right, second argument. PLACA does not have extraterritorial effects. There is, and I'm terrible with the case names, and I remember it was very hard in law school to remember the cases. There's a presumption against extraterritoriality. For those that are not attorneys, basically, if the law doesn't say that it's extraterritorial, there's a presumption, but there's another step that has to be addressed. Is the focus of the statute is directed. You see the focus to decide if it has extraterritorial effects. We insist that PLACA, in the way it's written and the way it should be read, do not have extraterritorial effects. Therefore, our case should continue. And a third line of argumentation is, if PLACA were to apply, we invoke certain exceptions. There's PLACA, the statute that offers these immunities, contains certain exceptions, and mainly one that we believe we can resort on is that if the defendants or the companies or the individuals we're suing violate the state or federal law, they cannot resort on the immunities. And our claim is that the 8 defendants in the Boston case violate state law. In the case, in the Boston case, we say it's the Connecticut Consumer Protection Statute, and also a similar statute in Massachusetts because of their deceiving marketing, but also federal law in the US that prohibits the selling of machine guns or devices that are easily modified. Also, the defendants violate Mexican law by allowing or facilitating the exportation of machine guns into Mexico. This is the Boston case, got dismissed. We already filed our notice to appeal. We're working on the briefs, and we expect a lot of amicus briefs to be filed before the Court of Appeals of the First Circuit, also in Boston. In parallel to this, we filed a second lawsuit. This is a staggered strategy. And this lawsuit is against 5 dealers in Arizona. What is that we claim in the Arizona case? That the dealers that represent 5 of the 10 worst actors in Arizona and 5 of the worst actors throughout the 3 states where the majority of the weapons are trafficked into Mexico, including Harris County. Harris County is number 3 of the places where weapons are traced to that are found in criminal scenes. This, the Arizona case, if you were thinking the Boston case, well, the causality is very difficult to identify. There's too many actors involved between what happens in Boston and a shooting in Mexico. It disappears the liability when there's too many actors. Those are arguments of the defendants. I'm misrepresenting them a little bit. In general, that's what they said. I'm not liable. I'm too far for what happens in Mexico. But in the Boston case, we said, you're negligent because you're willfully blind to what your dealers do. So we have dealers at the border in Yuma, Phoenix, and Tucson that are selling to straw purchasers. I'm talking about now the Arizona case. To straw purchasers, multiple sales. They're selling out of inventory. They perform repeated sales. These are the stores, brick and mortar stores that are selling the Barrett 50 to a first-time buyer. They disregard all the red flags. A first-time buyer, a person that buys every single day one weapon, those are red flags that for a responsible and diligent trade person should make them aware that something wrong is happening. When the auto industry identifies that their product, their car, their wheels, their tires might cause harm, they immediately recall their vehicles. It should happen the same in the gun industry. So we don't have that much time, but there's 2 specific allegations that we make in the Arizona case. In June of this year, the Bipartisan SAFE Act was enacted, and it contains the illicit traffic of weapons. For the first time, as far as I'm aware, in the history of the United States, illicit trafficking is a felony. It wasn't a felony. It wasn't a felony, and Mexico has been suffering for 2 decades of this flow of weapons, and in the United States, it wasn't a felony. Well, now it's a felony. So these dealers are breaking the law by facilitating and routinely and systematically selling weapons to traffickers. And also that law establishes that a straw purchase is a RICO offense. This is the Corruption Act. Our similar law in Mexico is an anti-organized crime law. So what we claim in the complaint is that the defendants are part of a trafficking ring where they facilitate the selling of firearms to traffickers. Why is important Arizona and Boston? A lot of people have asked, like, you're suing in Arizona because you couldn't make it in Boston, or you should have sued in Arizona first. My hope was that suing in Arizona and immediately the defendants in Boston. See, the bad guys are those. let's get together with the government of Mexico. Didn't happen. What is going to happen? What is the link between Arizona and Boston, as I have stated several times? What happens in Arizona is an example of the negligence in the Boston case. We will get the discovery in Arizona. And at some point, when it gets reversed and remanded, that's our hope, the Boston case will get into discovery in Boston, and we'll see the degree of knowledge that these companies have on the way they conduct their business. Before I end and open for very interested in listening to the comments. The government of Mexico is not against the gun trade. We have no say in what happens in the United States, but we have a say when they're killing us in Mexico. So if there's going to be a gun trade in the United States, we want it to be responsible, transparent, and with accountability. The weapons that are sold in the United States should remain in the United States. The laws that apply to gun control should be constrained to the US jurisdiction. It shouldn't frustrate our access to justice. That's why we're suing. And these lawsuits do not try to move us away from our own responsibilities. Customs, rule of law, investing more in security, doing more to prosecute the criminals. But let's remember, the lawsuits are law lawsuits, they're civil lawsuits. There's nothing to talk about customs or corruption. That's a different conversation. This is about the negligence, the lack of care, and the willful blindness of what has been happening since the assault weapons ban expired in the United States. An increase of firearms trafficked into Mexico from the United States. Thank you very much. I'm looking forward to your comments.
Thank you, Alejandro. Thank you. Stop sharing, probably. I think we have online Professor Tim Webster. Professor Webster, are you there?
I am here. Thank you.
Oh, okay, thank you. Welcome. So Professor Tim Webster teaches international and comparative law at Western New England University. His fields of concentration gravitate around the intersections of international law and the domestic legal systems, as well as East Asia legal studies in fields such as human rights, international trade, foreign investment, and transnational litigation. He has presented his research over 150 countries around the world and has testified before Congress and written for local, national, and international media. Professor Western has served on committees for the American Society of Comparative Law, American Society of International Law, American Association of Law Schools, and Asian Society of International Law. So, Professor Webster, a case that involved two nations and transnational litigation. So we will appreciate your comments.
Awesome. Thank you. Let me begin by thanking the University of Houston, which has, as I'm sure you guys know, one of this country's leading international law programs. So when your dean reached out to my dean, I, of course, jumped at the chance. So I thank Dean Baines, as well as Dean Tennessee and Sonny Lim for making this opportunity available to me. And I'd also like to offer my congratulations to Attorney Alejandro Celorio. I know you didn't win the lawsuit in Massachusetts, but as I hope to make clear in my comments today, I'm not sure we should judge your suits, I suppose we should say, by the common standard of whether you won or lost. And so what do I see your lawsuits doing are two very, very important things that I'd like to spend some time talking about, and then I'll have a couple of questions for you as well. First, I think it's helping us reframe the debate about gun rights in the United States. I think that's crucially important, and I'll explain why that's the case. And then I'll see this as an attempt to solicit judicial input and judicial authority into this broader discussion of how we can provide remedies to people who have been victimized by gun violence. So the gun debate, and then the role of courts, let's say, in this broader discussion. So as I'm sure you're aware, the gun debate in the United States focuses almost exclusively on internal matters, on the constitutional right in the Second Amendment or state constitutional rights. And we are almost exclusively concerned with the harm done to US citizens. And what I think this lawsuit does a wonderful job of explaining and showing is that the victims are not simply our children, right, who are mowed down monthly in school shootings in the United States, but there are thousands of Mexican victims as well, right? So again, it's not simply a United States issue. Instead, it's an issue that has ramifications across the border and with quite deadly consequences for, as Attorney Celorio mentioned, tens of thousands of Mexicans every year. So, the US, as probably many of you are aware, is an outlier when it comes to gun ownership and gun regulation. We have less than 5% of the world's population, but 46% of the world's guns, or I should say civilian-owned guns. And I think we in the United States have largely grown inured to gun violence. My son has active shooter trainings, he has lockdown drills, and we consider this, the price of living in a modern civilized society. It's important to point out that among developed states, we have the highest gun homicide rate in the world per capita, 4 times higher than Israel and 8 times higher than Canada. And so as this lawsuit, I think, is helping us focus attention from the United States to Mexico and to international or transnational law more generally, I think it may be helpful to realize that we're not the only country here, and that countries that have dealt with episodes of massacres or widespread gun violence have actually taken action to stem that, right? And the 2 leading examples of that are Australia and New Zealand, both of which suffered mass shootings, Australia in the 1990s, New Zealand in 2019. And both countries use those events as catalysts to introduce much more restrictive gun laws. Okay, so it can be done. It has been done. The United States is different. I understand we have a much stronger gun culture. We have lobbying groups like the NRA that make change difficult. But I think it's important to point out that other countries, right, English-speaking common law jurisdictions like New Zealand and Australia, have used these mass shooting incidents to reform their gun laws and make their societies safer, right? So again, one of the key factors of this lawsuit, and one reason I'm optimistic about it, even if you don't win, I think you are changing the terms of the debate, and that's sometimes what's necessary to effectuate social change, as I hope your lawsuit will do. The second thing I'd like to talk about is understanding these laws as examples of transnational public law litigation. So at the beginning of his remarks, Attorney Celorio mentioned transboundary torts and extraterritoriality. I'd like to introduce a couple of theoretical concepts as well. The first is this idea of public law litigation. And the second is sort of a twist on that, which is to say transnational public law litigation. Now, public law litigation is the basic idea that civil litigation, right? So here we have one party, Mexican government, suing 8 parties, American gun manufacturers. And typically we might think of that as a private dispute between parties, right? But this idea of public law litigation says, even if the parties themselves are private actors, right, a plaintiff and one defendant or multiple defendants, as the case we have here, they are speaking to issues that are much broader and have a public law or a public or a structural component to them, right? So think about Brown versus Board of Education, think about Loving versus Virginia, think about Obergefell versus Hodges, private disputes, but with much broader public law implications. And so, it may be the case that this lawsuit loses, and maybe the case in Arizona will lose. But I think if we understand it as part of a much broader debate and a much broader conversation, maybe we can take those losses a little bit more. We can swallow them with a bit more acceptance. Now, transnational obviously means, in this case, we have parties from different states. Harold Koh, the former dean of Yale Law School, thinks of transnational public law litigation as something where you have parties from different states, as we have here, who are seeking out a prospective focus. We want to change the future. We want to change the way, for example, guns are sold and distributed in this country. And we want to do it by creating new forms of dialogue between domestic actors, lawyers here in this country, or advocacy groups. And you saw the slide that had all of the amicus briefs that have been submitted on behalf of this case, and international actors, right? So consul members from the Mexican government, maybe other activists in the United States or Mexico who are interested in gun rights issues. And so with that, I think we can ask ourselves a different set of questions to figure out what effect these lawsuits are having, right? So one common theme in transnational public law litigation is how is it being discussed? Who is talking about it? Are the media covering it? What kind of media representation are you getting? And here, I did some brief Google searches, and there's plenty of coverage in the United States and Israel and Canada and Mexico and so forth. So clearly this has captured at least some, small segment of public attention. I think that's really important. Second thing does it create new norms or new kinds of information or discourse? And particularly, does the judgment itself? Now, as Alejandro mentioned, Judge Saylor did dismiss this case, but he made, I think, some really important findings. And Alejandro mentioned those, right? For example, that Mexico has standing, meaning their damage is being done to Mexico. There's one passage I'd like to read for you, because I think it really helps nail down this issue. So again, this is Judge Saylor, the United States District Judge here in Boston, who dismissed the case. This is something that he wrote in his opinion. He says, the indirect causes of all the violence in Mexico are no doubt many, but surely a substantial portion of the blame rests with American citizens. The rise of Mexican criminal organizations has been fueled by the unrelenting demand of Americans for illegal drugs, and those same organizations now play an ever-increasing role in the smuggling of illegal migrants across the border. The complaint here focuses on an additional indirect cause, the marketing and sales practices of American gun manufacturers, right? So true, the case was dismissed, but I think if we actually read the opinion and read between the lines, we'll see that Judge Saylor is certainly sympathetic to the cause, as was suggested. You have PLACA, this gun immunity law that Congress passed, and we can discuss how democratic we think that is. He's making this argument that his hands are bound, but yet beyond that, I think he is sympathetic to the kinds of claims that the Mexican government and others have made here. A third thing to think about is, does this create political pressure, right? Again, so yes, you've lost the lawsuit, but what are the silver linings, or what else has been generated from this? And I think it's important to point out, and again, I don't know if there's linkages between the Mexican government and what's going on, but in at least two northeastern states, the Attorney General of New York and the Attorney General of New Jersey are investigating gun manufacturers or gun distributors for fueling gun violence towards New Yorkers and residents of New Jersey, right? So again, it's not the typical case, but we're sort of thinking creatively. And I wonder, again, I don't know if Letitia James in New York, for example, followed suit or was inspired by the lawsuit here in Boston, but it seems to have been, creating a dialogue or discussion with state actors, right? In this case, state attorneys general, to think, okay, are there other ways we can think of this? Letitia James, the Attorney General, is investigating this as a public nuisance, right? The gun violence that the flow of weapons has created actually amounts to a public nuisance. Okay, so that's sort of the bright side of this. I'd like to finish my comments just by raising a couple of questions. One, and Alejandro, you mentioned this in your remarks. You said you did not choose to bring cases on behalf of victims, and you said that that might have gotten a somewhat better response in terms of remedies. And I wonder if there's a possibility of a third lawsuit, right? So we have Massachusetts, we have Arizona, but I wonder if we could, again, I've characterized this as transnational public law litigation. I wonder if we might think of it as a transnational human rights issue, right? Because Mexican kids are dying, Mexican citizens are dying, and that, of course, is a human rights issue. The right to life is the fundamental, bar none, human right par excellence. And the ease and the widespread distribution of American manufactured guns plays a role in directly killing or ending life, right? So I think we could also view this or understand this as a human rights lawsuit or transnational human rights litigation. Again, if another lawsuit came about where victims or the families of victims and so forth, that was highlighted. I think that would also get better media attention. That might get a better political response. You might see some of these secondary effects I've talked about sharpening if there were an additional lawsuit that focused on the victim. So that's one sort of nest of questions I'd like you to address. And then finally, I also see a cheap solution to this, which is the United States government saying, well, we'll try to crack down on gun movement from, as you showed the slide, from Colorado, New Mexico down to Mexico. And so we will beef up border security to prevent the flow of guns from the United States to Mexican cartels and others. And so I wonder, Alejandro, and you've been very modest and said, this is not against American citizens, it's not against the United States government. But I wonder what you would see as a positive step from the Biden administration or from the United States government as an adequate response to this lawsuit. So I raised both of those questions. An additional lawsuit that focuses on the human rights implications of this, and then B, what would a suitable response from the United States government? I know you haven't sued the United States government, but it seems to me the U.S. government is one of the silent actors here, even if it's not a defendant in the same way that Smith & Wesson or Beretta or some of the gun dealers in Arizona that your second lawsuit has taken on. So I'll end my comments there. Again, I congratulate you for this lawsuit, for the incredible work you've done. I'm not sure how sympathetic American courts will be, but I think you are now attracting a much broader audience, and I congratulate you for that. Thank you.
Thank you very much, Professor Webster. So we will transition to Professor Bregan, and then you answer the questions. So we have also the pleasure to have Professor Jessica Bregan. She's an assistant professor of law and associated faculty in the Department of Psychology at the University of Houston. Her scholarship focused on experimental method from psychology and economics that have an impact in the law. Among other topics, she has written about the expressive functions of punishment, children's benefits and expectation about rulemaking, lead perception of settlement, and the intuitive origins of private ownership. She currently teaches in the areas of property law, criminal procedure, and alternative dispute resolution at the University of Houston Law Center. So we're very pleased to have Professor Bregan in the room. Thank you.
Thank you. I'm gonna use the podium because otherwise I'm not sure I can project well enough to be heard by the folks on the on the call. Thank you so much for the introduction and for a fascinating talk. I'm so glad you're here, Alejandro. I thought I would talk just for a minute about what Alejandro has called the elephant in the room, that is PLACA, and in particular, the past and future of PLACA, because I think there's a lot of interesting parallels going on between sort of the history of gun legislation in this country and the real costs and problems that we've just heard about. So the history of federal gun laws in the United States is a story of violence, and especially a story of political violence. The first national gun law was the National Firearms Act of 1934. And it was a reaction to, among other things, the violence of the Prohibition era and the gangsters who were seeking to evade Prohibition agents, as well as a 1933 assassination attempt on then President-elect Franklin Roosevelt. Roosevelt was not hit, but the assailant, who had purchased a pistol for $8, did manage to hit and eventually kill the mayor of Chicago, who was with Roosevelt at the time. The next year, in 1934, the congressman who introduced the National Firearms Act said something that I think will sound remarkably modern. He said, "For some time, this country has been at the mercy of gangsters, racketeers, and professional criminals. The rapidity with which they can go across state lines has become a real menace to the law-abiding people of this country." Appropriately enough, since it was directed at figures like Al Capone, the NFA is a tax law. It positioned itself as a use of Congress's power to regulate interstate commerce and empowered the Treasury Department to tax the production and transfer of various kinds of firearms, including shotguns and rifles with barrels longer than 18 inches, et cetera, et cetera. The tax, incidentally, was $200 for possession and ownership of these, or the transfer of these weapons. That's roughly $4,200 in today's money. Generally, it was considered to be a pretty serious tax, and it was designed implicitly to reduce the trade of arms. The tax is still good law, and it has never been changed, so it's still $200 today. The next major firearm legislation, the Gun Control Act of 1968, was also passed in response to high-profile political violence. The 1963 assassination of JFK reignited discussion about firearm control in this country. And in 1968, the assassinations of Robert Kennedy and of Martin Luther King Jr. coincided with the Supreme Court's decision in Haynes versus the United States, which invalidated a portion of the National Firearms Act for reasons that we can get into over a drink if you want to talk about it later. The GCA is a massive piece of legislation that shapes a lot of our current federal gun policy still. It imposed stricter licensing and regulations on the firearm industry. It created new categories of gun-related crimes. And it imposed the first federal jurisdiction over destructive devices, which included things like bombs and mines. The GCA also revised and amended the NFA, curing the constitutional defect the court had identified. And for the first time, the GCA banned the sale of firearms and ammunition to convicted felons. Since 1968, the major firearm legislation that's been passed has largely amended or extended the GCA. And often it's been with an eye toward who should and should not be able to own a firearm. So in 1986, Ronald Reagan, who had himself been the victim of an assassination attempt, signed a bill that relaxed some of the GCA's provisions that imposing criminal sanctions on gun owners whose weapons were used in the commission of a crime. In 1990, as part of the Crime Control Act, Congress passed the Gun-Free School Zones Act, making it a crime for unauthorized people to carry guns in school zones. In 1993, the Brady Act, named, of course, for Ronald Reagan's press secretary, who was paralyzed in that assassination attempt, established the National Instant Criminal Background Check System, the NICS, a national database of people prohibited from purchasing guns. The 1996 Lautenberg Amendment extended the list of people who were prohibited from owning firearms from those convicted of a felony to include those convicted of misdemeanors of domestic violence. In 2007, the Congress allocated additional funds following the mass shooting at Virginia Tech by a gunman who should have failed the background check, who should not have been able to purchase a weapon. Okay, Then in 1998, the first big settlement agreement was reached in the big tobacco cases. Stick with me. More settlements followed, right? As tobacco companies agreed to pay millions of dollars to redress the ongoing national health crisis that cigarettes and other tobacco products had helped to cause. People immediately began to speculate that the litigation model used in those cases against the tobacco companies could be a useful template for addressing other public health crises, including the opioid crisis, which has so far used a very similar model, and the epidemic of gun violence. Enter PLACA. In 2005, the Protection of Lawful Commerce in Arms Act includes the following language in its preamble. The possibility of imposing liability on an entire industry for harm that is solely caused by others is an abuse of the legal system, erodes public confidence in our nation's laws, threatens the diminution of a basic constitutional right and civil liberty, invites the disassembly and destabilization of other industries and economic sectors lawfully competing in the free enterprise system of the United States, and constitutes an unreasonable burden on interstate and foreign commerce in the United States. As we heard, right, PLACA's primary purpose is to foreclose liability against gun manufacturers. But it's been very successful at that, as we've seen. But there are a couple of recent cases that provide some reason to think this won't be the last word. And mindful of my time, I'm going to talk about them very quickly. The first is one that Alejandro mentioned, right? And it's the Sandy Hook litigation. That is Soto versus Bushmaster Firearms, which is a Connecticut Supreme Court decision following the lawsuits brought by survivors and victims of the Sandy Hook Elementary School shooting. The families brought suit against the manufacturers of the AR-15 assault rifle that was used in the tragedy, claiming that the manufacturers had engaged in wrongful advertising under the Connecticut Unfair Trade Practices Act, which the government of Mexico also relies on in the Boston case. The plaintiffs alleged that the Bushmaster and other gun manufacturers had advertised the AR-15 in a manner that was unscrupulous and encouraged dangerous conduct by, among other things, touting the weapon's usefulness for waging war and killing human beings, and claiming that the weapon would allow a single individual to outnumber his opponents and force them to, quote, bow down. In the trial court, the manufacturers moved for dismissal, citing PLACA, and they won. But the appellate court reversed, and the Connecticut Supreme Court agreed. They concluded that a wrongful advertising claim under the CUTPA fell within what's called the predicate statute exception of PLACA because the CUTPA prohibits unfair methods of competition and unfair or deceptive acts or practices in the conduct of any trade or commerce. Other attempts to use the predicate law exception of PLACA have generally been unsuccessful because some courts have held that to qualify for the exemption, the would-be predicate statute in question has to specifically call out that it applies to firearms manufacturers, right? So as Alejandro said, the exception permits claims against weapons manufacturers when the claim is based on a state statute that is applicable to the sale or marketing of firearms. The second case is a little bit more of a stretch, and it's a products liability case from September of 2020 called Gustafson v. Springfield, and it's a Pennsylvania appeals court decision. It comes from the accidental shooting death of a 13-year-old boy, J.R. Gustafson, by his 14-year-old friend. The boys were playing with a semi-automatic handgun manufactured by Springfield Armory when the older boy removed the magazine clip from the weapon and, thinking it unloaded, fired it at his friend. Although the clip had been removed, it turned out there was a bullet remaining in the chamber and JR was killed. The Gustafson alleged that Springfield negligently sold a weapon that did not indicate in any way that it was still loaded, or stopped the firing of the weapon after the magazine had been removed, suggesting that the possessor of the firearm did not, in fact, wish it to fire. FACA comes up in the trial court, but the Pennsylvania appellate court decision goes further than the Soto decision did, because the Pennsylvania appellate court ruled that PLACA is an unconstitutional abrogation of the powers reserved to the states under the 10th Amendment. The Commerce Clause, the court reasoned, could not justify this usurping of the state's management of its own tort laws. FACA reaches out and pulls J.R. Gustafson and his parents into the financial service of the gun market, the court said. It also cited in its decision U.S. v. Lopez, which is a U.S. Supreme Court decision that had invalidated the Gun-Free School Zones Act as not an applicable or not a valid use of Congress's interstate commerce powers. The future of all of these cases is unclear, especially with a conservative majority on the US Supreme Court that has endorsed expanded views of the Second Amendment and seems disinclined to limit the availability of firearms in this country, at least. However, the federalism argument that the Pennsylvania court accepted in Gustafson might be particularly appealing to some members of the court. Jonathan Lowy, who represented the Gustafsons, pointed out that his arguments rely on, among other things, several decisions written by former Justice Antonin Scalia. Speaking to Reuters, Lowy said something that I think is a nice bookend because it picks up right where Alejandro began his talk. Lowy said, if the justices are principled, their view of the Second Amendment will have nothing to do with it. Thank you very much for your time.
Thank you. Thank you, Professor Vega. Thank you so much. Alejandro, you have two questions.
I'm going to start by thanking both commentators for your very useful. I was taking notes. Jonathan Lowy is our attorney in the case. So, and I'm mentioning not only to honor his work, but because we are building upon the effort of US citizens. And this is beautiful in transnational litigation. It's not Mexico against, no, it's together as society doing this effort. And to respond to Professor Webster, in terms of human rights, so we're a firm believer in exhausting all available remedies. So we came to the US, we're suing. We are suing in Arizona. We had a public hearing before the Inter-American Commission of Human Rights. We're drafting a request for an advisory opinion from the Court of Inter-American Human Rights. Some might think there is naive to resort in the Inter-American system to bring accountability into this issue, but it's important to exhaust all available resources and eventually the issue will be denial to the access of justice. I think it's important to keep that in mind. Courts should be open to seek redress. That's our belief, but that's perhaps in the next years we'll keep discussing this. If US courts are still not available for those that are harmed abroad, I think it's important to think about the human right of equal justice. In terms of specific actions of the President Biden's administration, we're already seeing a lot of actions. So we feel very encouraged of what the US federal government is doing. More prosecution. There's more news of indictments against traffickers. There's a task force in the US territory. We still need a task force for international trafficking, but there's a task force addressing the interstate trafficking from lax regulated states into heavily regulated states, Texas to California. Those guns that are trafficked from Texas and to California go down into Mexico eventually. We would like to see a surge in agents at the border, perhaps more ATF helping local authorities like in Harris County to prosecute traffickers. The guns are out there in the streets hurting civilians, but also law enforcement agents. So I think in honor to their service, we should all be working to take the guns out of the streets in Mexico. That is our claim, but also in the United States. Thank you very much.
Thank you, Alejandro. Is there any questions from the participants here in the room? Anybody who wants to? Yes, please. Can you identify yourself, please?
My name is Señor Alejandro Garcia. I'm in my last year of the LL.M program here. I studied my first licenciatura in Universidad de las Américas, Puebla. In any torts case, there's a remedy that is sought to obtain by the party that the plaintiff. Let's say that this case goes forward and there is indeed a judgment and there is a settlement and not a settlement, but there is an award. What is your position as the legal counselor in this case where do you plan on putting that reward money towards? Do you plan on giving that money back to the thousands of people that have been affected by gun violence in Mexico? Or do you plan on using that money to fund finally a program in Mexico to possibly legalize the narcotics that are coming into the United States, such as marijuana and other recreational drugs?
Thank you very much for the question. Both cases, the Boston and Arizona, we ask the correspondent judge to order that the industry, the defendants, change their practices. And I wanted to start by saying that it's not only about the money or the economic compensation, it's about changing their practice. That's another reason why we sued in the United States. Our case wasn't dismissed under forum non-convenience, but we wanted to sue here to enforce an eventual judgment. A US court's judgment will have to be chasing the defendants, and it's extremely hard, if not impossible. Now, in the Arizona case, we're asking the judge to designate monitors to supervise the way they sail, because the defendants and other companies will say, it's difficult for me to identify the straw purchasers. Don't worry, the judge will put somebody that will help identify them. Now, in terms of the money, what would we do with a potential award? The way the federal bureaucracy work in Mexico and our system, any money that enters our treasury goes to the general funding of our public expenses. Now, it is for the Mexican society to request that money, is just like taxpayers' money, be used in specific things. And I applaud your comment because we're going to win eventually. And if we start talking about what should we do with that award, is a worthy conversation, because we need to be ready to implement it. Be hard to give a compensation to the victims, like in any case, extremely hard. How do you decide who's a victim of what and the amount? No, it's unmeasurable, the cost of life, right? But I think ideas like yours of funding certain actions or certain programs is a good way to go.
Thank you. And just a follow-up, if you were to be offered a settlement option and not going forward and not going to judgment, would the Mexican government accept that settlement and avoid the trial, or would you plan on going the full way?
The instructions that I have and what I would like to do is to go all the way.
Okay.
Why? Because in 2001, I might be mistaken with the years, Smith & Wesson reached a settlement with President Bill Clinton's administration, and a lot of the elements of that settlement, or wasn't a settlement, was an agreement to avoid a litigation. We included in our Boston case. That agreement was never fulfilled. So all the commitments by Smith & Wesson weren't fulfilled. So a settlement agreement, I'd rather have a judgment so it can be enforced.
Thank you.
Okay. Yeah, Carl.
Yes, and I know we're pretty much out of time, but it looks like there's one question online.
Okay.
And the question is, what is the expectation on the result of the trials? or is it just as precedent?
Thank you very much. One of the questions that we receive often at the beginning, not so anymore, is if this was a political stunt, or we just wanted to make noise or make a point to the president. No, this is a torts case. We suffer harm. There's people that have died. We are suing for that. Now, it has fortunate coincidence or elements that are building up like this presentation, but the lawsuit has a legal argument, and there's a reason why we are suing. Now, it's a strategic litigation. It's not a black and white lawsuit. It's a strategic litigation. The way we did it, who are we suing, when, where? So as part of the strategic litigation, it may seem that it have more of a narrative element, but it has a legal objective. And the narrative element is an accessory that is beneficial for the conversation.
Okay. I think we have run out of time. I would like to thank for those connected online, also Ambassador Kerber and Consul Garcia for participating in attending the talk, and to all of you who attended today to the presentation, the commentators, and Alejandro. Thank you very much. Okay? Thank you.